And welcome to Recovery Report Live. I'm Dan Odess, president of GlobalPro, where we manage risk to recovery. We've managed more than $1 billion in recovery. We've helped thousands of policyholders place insurance throughout the years, 10 years right now. We're headed into the obviously the holiday season, and we are celebrating a lot. We've had a lot to celebrate this year at GlobalPro, despite all of the loss and disaster that's gone on. We've been on the front lines helping our communities recover and rebuild. It's what we've been doing. It's part of our culture. It's something we will always and will continue to do. As you can see, I'm not in the Griffin studio. I'm on the road. I'm actually in New York. You can see the beautiful skyline behind me. Everyone's telling me that maybe the lighting isn't just right, but I couldn't resist to include it behind me here. I am having an amazing time meeting with clients, sitting down, having dinners, lunches, and getting to catch up on what has gone on in 2023. 2023 is our new year, new normal. It was a different type of year. It was a year that we all finally got together. It's a year that allowed us all to finally be in the same room together, act normal, and do the things that we all love to do. Whether it's the continuing educational things, whether it was just the simple engagements or the dinner that I went to last night with a bunch of real estate clientele up here in New York, some of the decision makers on a tremendous amount of multifamily. We were able to sit down, talk about things that are going on, what's going on in the insurance market. They got a tremendous amount of real estate in the Florida markets as well as Texas, and they are concerned. They're concerned with where things are going. And I keep getting asked this question, and it's what I wanted to focus on here this morning as my introduction. What is the state of the market and what should we expect in 2023? Well, first of all, in Florida, I would say that we have a weak governor when it comes to insurance. We have a weak legislation when it comes to insurance and keeping our insurance companies honest. Our CFO is weak on consumer rights and protections, and unfortunately, that's culminating in probably one of the worst insurance markets we have seen in history. Now, I believe that they all can be strong on insurance for consumers. I believe they can all take this step in the right direction. I believe this because I've actually heard some grumblings and some commentary about accountability. Finally, okay, I've been desperately asking for accountability for insurance companies in their reporting requirements. A lot of the focus has been on lawsuits and public adjusting, and there's been some words thrown around like locusts and predators and whatever else for contractors. Now, honestly, most of it, I would say, majority of it is honestly not necessary, is not relevant, and certainly not warranted. So I would say though that unfortunately, because of the campaigning and the lobbying, the strong lobbying efforts by insurance companies, their voice has been heard loudest. They seemingly don't like to talk about the actual statistics behind things, don't want to report on these things, but just simply want to make broad stroke allegations and statements regarding things that are leading to issues in the market. And when you question them on those things, like this last legislative session in Florida, where even after it, they had a special session, they went in there on the premise that they were going to make a better market for homeowners. Well, what came out of it was broad stroking changes for insurance generally. Now, I don't quite understand the disconnect and why people kind of bundle the issues regarding homeowners with commercial lines of insurance. It does not make sense in and in itself. And when they do that, it demonstrates their lack of knowledge and experience. And sadly, it shows how poorly they are representing these issues and dealing with the issues that are actually plaguing the insurance markets, not just in Florida, but throughout the countries. I would even say here in New York, there's so much legislative changes that can help the state of New York. There's many discussions here in New York about bad faith and bringing it back, or at least having some semblance of it. In New Jersey, we saw after Superstorm Sandy, the bad faith got challenged, and sadly, they changed the precedent in order to obtain such bad faith and attorney's fees. And you saw an immediate change in direction of claims. They started taking longer. There were less payments being made. The struggles, in fact, litigation increased. You saw an increase in the amount of litigation. So when they say they're doing these things to protect you, the consumer, I can believe me when I tell you, right now, I haven't seen a piece of legislation yet that has actually protected the consumer. In fact, it's actually, when they say they're protecting the consumer, most of the legislation I've seen, both in Florida, Texas, New York, and particularly in California, it's shifting the burden and obligations from the insurance company onto the consumer and holding them accountable for what their contractors and public adjusters and all these other representatives are doing, but then stripping them of the opportunity to engage representation by, quite frankly, if you do a cost benefit analysis, it makes it incredibly difficult for someone to operate and to provide services, and to be able to pay their own expenses and bills to be able to do and provide those services. So when we saw this legislative changes in Florida regarding attorneys' fees and now having to use some sort of metrics to figure out whether or not you've been successful, even if you even proven that the insurance company did not properly pay a claim, they still want to judge whether or not you proved it enough. And that's, then you talk about the changes in the roof. Now, and I speak a lot about Florida. Obviously, we're headquartered in Florida, but Florida becomes a bellwether state for a lot of other legislative changes throughout the country. We have seen many different states follow suit and adopt some semblance of what goes on in Florida, and with this idea that they're also going to protect the consumer, they're going to help, they're going to do these things. And I hope that many other states do not take the lead from Florida from this prior special session. Even the legislators themselves coming out of the session said that the changes that were made will not help the consumer in 2023. So when I'm asked about the market in 2023 and what to expect, and we're looking at rates and we're looking at products, right? Now, brokers are saying that, well, rates are comparable to what you were paying in 2006, 2008. But what they're not saying is that the product you're buying, though, is so inferior to what you may have been able to buy then that it's not comparable. Yes, the cost may be similar, but the product you buy is so inferior that it's not even. There's so less coverage. There's such less in that product that you're buying for that same price, that it's not a factual and good statement. It's nothing. It's not something that we should be promoting. But they're promoting it to justify their commissions. And I tell you, all this time and on this broadcast and many other times, start to negotiate these things. Start looking at those opportunities as we head into the 2023 year, and as you're going through renewals and you're budgeting. If you're a community association, you're tuning into this, make sure you're considering these things. We need honest reporting by insurers. We need it. We asked for it in 2000. Actually, in 2020 and 2021, there was legislation passed which would require the type of reporting to justify the campaigning for higher rates and further restrictions on consumers. Sadly, before the special session, that information ironically was not available. When questioned about it, the reaction is that, well, we interpret those laws differently. We don't believe that reporting's due until 2024, maybe 2025. But you're making the changes today. So why would you not want that reporting? They say that most of the litigation is going on in Florida. That's causing the rise of insurance. I question that. I say, show me the dollars. I don't care about the percentages. I want to see the dollars, because the dollars are what translates to losses that they allege that they are incurring, and that they need more revenue, they need more profit in order to justify their existence in Florida and in the coastal areas, to be able to be more competitive and to sell product. But they're not talking about the dollars. They're talking about some sort of percentages. And quite frankly, if I do my own research and look at the types of cases that they're talking about, I don't think it really adds up to any sort of losses that they're seemingly reporting here. Now, for our multifamily property owners out there, really want to focus in on what's going on in 2023. Know that a lot of those changes that we did see are going to impact you. So look for ways to sell yourself general liability insurance. Think about captives, self-retention, higher deductibles, negotiate your broker fees, way down. They should be way down. In fact, we should see historically low broker fees right now. Why? Well, because we're paying historically higher rates for our insurance and historically less coverage than we've ever gotten before. So as far as I'm concerned, if someone is selling me way less product, but trying to charge me way more for it, and they're receiving a commission on it, well, as far as I'm concerned, they should be receiving a hell of a lot less commission for doing that. Now, so go ahead and negotiate these things. Negotiate on commissions, negotiate on premiums, negotiate on rebates. There's also rebates. There's things that you could do where you can get rebates and there are other things that ask the brokers about this sort of profit sharing that they engage in at the end of the year when they reconcile losses and premiums. Property improvements, look for areas, capital improvements. Maybe there's a way that you can improve your product. Maybe it's cheaper to improve the product with a higher self retention or higher deductible, which may lead to a more competitive priced product or insurance product that might actually offer you more coverage. So look at those things. Those are some of the tidbits on it. Anything we can do for you, obviously reach out. That's what we're here for. At GlobalPro, we've been doing this for over a decade, making sure that our clients have what they need. And I unfortunately, I think that the 2023 insurance market is going to be tough throughout the country. However, there are opportunities for you to mitigate some of that expense. There are strategies that you can employ to help with doing those things. Now, I've mentioned Texas, and we have our very own Rob Bowlby with us here today and a special guest. And I want to bring them on here right now to talk about some of the other things going on in our country, as well as some of the things that we talked about in the past, appraisals and the litigation environment. Jonathan, Rob, thank you guys so much for joining me here today.
Thanks, Dan. And so the title today is Why Insurance Companies Reject Appraisals. And so this is something that I saw earlier in the year. We started seeing this in some of the industry journals that some of the insurance companies, once you got through the entire appraisal process, was rejecting an appraisal. And then it happened to one of our own clients where we got through the entire appraisal process and we were ready for the payment, sent it into the insurance company, and they said, "Oh, we're still not going to pay." So this subject became very near and dear to my heart very quickly, and why it's one of the reasons we have you on today, Jonathan. And so before we get too far in the weeds, I am going to ask you to give a little bit of an overview of the appraisal process. But even before we do that, why don't you tell us a little bit about Gravely, about yourself, and kind of how you got into this industry helping people?
Thanks, Rob. I work with Gravely PC. We're a commercial litigation firm based out of Texas, and that's where most of our clients are based as well. Our primary areas of focus are insurance litigation, any type of coverage litigation involving first-party insurance, but also construction defect litigation and other types of contractual disputes between businesses. Most of our clients are commercial companies, but they're also municipalities, hospital districts, and other municipal organizations.
Okay. And then what kind of led you? And I asked this because you and I talked about this over breakfast a few weeks ago, where you worked before, and then kind of what got you into this line of business.
Yeah. So after undergrad, I went to the Army for 4 years. I was a military diver, engineer diver, deep sea diver for the U.S. Army, 86th Engineering Dive Team. But once I got out of the Army, I went to St. Mary's Law School, and I met up with Mark Gravely about a year after I started practicing law. And once I started working with Mark and learning construction defect litigation as well as this first party insurance type litigation, they really do dovetail a lot because they have a lot of common factual issues between them, but also a lot of common insurance related issues. So when you look at those two areas of law, especially in Texas, they do dovetail a lot, and there's some commonality between.
Okay. So again, today's topic is a little bit wonky for us insurance guys, appraisals getting rejected. And Dan, thanks for the Florida update earlier. And, insurance adjusting is just much more well-known in Florida. And I think a lot of people understand the adjustment process. They understand the need to have representation. They understand the appraisal process. Now, I was having lunch with a real estate developer yesterday. They have about a $250 million industrial portfolio. And we were talking about the process. And he said, "What do you mean appraisal? Like, is that we get a market value of our property? How does the appraisal even help in the insurance process?" And so I just don't think it's as well known in Texas. And so that's my first question to you is what's your experience? Do policyholders even know they have this right under their policy, and how often does it get used?
It's been my experience that most people do not know or are not aware of the fact that there is a very specific type of an appraisal clause that's found in property policies, especially in Texas. And so informing people about that, talking to them about it, and educating one is a big part of what we do. Most of the time, people come to my firm, they think about litigation. It's a lot of times in the medical field, they say, if you want surgery, go talk to a surgeon, right? And so a lot of what we do is spend time educating our clients, and we do things like we're doing today to try to educate, the entire all of the stakeholders, policyholders, but on both sides about what rights are available under an insurance contract. And one of those is appraisal.
Okay. So talk a little bit about that process. How does it work? What type of an appraisal is it? Kind of walk us through that process, please.
Appraisal has been in insurance contracts in Texas for at least 100 years. And so it's been around for a very long time, but it hasn't been used as much in property insurance policy disputes until within the last, 15 or 20 years, it started becoming more and more popular. It is a contractual right or an obligation that's found in the insurance contract between the insurer and the insured, and that's what drives that process. But generally and basically, it is a process where two and potentially three individuals who have a specialty in assessing, identifying, and placing a value on a loss get together and attempt to resolve the dispute about the amount of the loss. And so it's not just in the property context. You've seen appraisals, and there's a lot of case law in Texas on, auto disputes and the value of a vehicle and things like that. So you get someone, and you hope that within the appraisal process, you have folks that understand that particular type of property. So if you're talking about a commercial property, you want an appraiser who understands how to either rebuild, construct, or value that type of commercial property. But the way the process typically works is that each party, the insurance company and the insured, selects an independent appraiser, and those two folks go visit the property and attempt to set an amount of the loss for whatever the covered damage is for that particular issue. So most of the time, you hear about hail, it could be roof. That's one simple, type of example. But they would go look at the roof, they would discuss it, they would both create an estimate, and then they would compare those and see if they can discuss it and come to an agreement. If they're unable, those two appraisers, to come to an agreement, then an umpire can be selected, and that umpire assists the two appraisers in resolving that dispute about the amount of the loss. An agreement between either of those two, any two of those three folks, sets the amount of the loss. Now, that is a very generalized way that appraisals work in Texas.
Yeah, Jonathan, I want to jump in here real fast, Rob, if you don't mind, because one of the things I just recently experienced, actually, we had an appraisal on a fairly large commercial loss, and we got a retired judge as an umpire, and he wanted to engage in an arbitration process within the appraisal process itself. What are some of the rules around how the process is supposed to be conducted, and what role should the umpire play in the process?
Well, that's a very interesting question, and that's oftentimes where the educational component of for clients and stakeholders comes in Texas, is because there is no, outside of down in the coastal areas where you have the TWIA defined statutory appraisal process. Typically, the rules of an appraisal process are confined to the terms of the actual policy at issue. And so if the policy is silent, sometimes it kind of becomes a little bit of the Wild West with what a particular appraisal panel can or cannot do in a certain circumstance, because there's not any statutory background in Texas that says, here's how you have to march through an appraisal process. And very often those appraisal clauses in a policy are vague. It talks a lot of times about how you have to appoint an appraiser, how an umpire is selected. But at the end of the day, they'll be vague and say, and a decision by two of those three people will result in a determination of the loss. And that's it. It doesn't say how you have to. It doesn't say you have to actually go out and look at the property. There's really no specific requirements other than what's contained in the policy.
Dan, one thing I've noticed is a lot of the boilerplate forms have gone from, when you want to pick an appraisal, it's either the insurance company or the insured can opt to invoke the right to appraisal. And now a lot of these boilerplate forms say the insurance company and the insured has to agree to invoke the right to appraisal. Now, the other thing that I've noticed, though, and it's anecdotal because I've noticed it in two policies, is that the Texas modifications have changed it back from and to or. I don't know if that's anything under Texas statute or not, but when they add the Texas endorsement, it changes that clause to say either the insured or the insurance company can invoke the right to appraisal. And I don't think people realize what a big deal that conjunction is, because without that or there, if the insurance company doesn't agree to go to appraisal, you can't go.
Well, and I've been up to the Court of Appeals in Texas on this very issue where you had a unilateral appraisal clause. And so I've dealt with that. And that's probably one of the reasons. And I don't claim to know why insurance companies change their policy forms and for what reasons. And I was laughing earlier when I saw the why insurance companies reject appraisals title for today. A lot of the questions I get is, why did the insurance company do this? And, my often frank reply is, listen, we could spend a lot of time trying to figure this out, or we can try to fix the situation.
Yeah.
But
amen to that. Yes.
And that's okay. Look, that's not what my job is and what my role is here. But the fact is, unilateral appraisal clauses in Texas will almost never fly. The case law that we have on that is fairly tight, and it's likely not going to be something that you run into an issue that you wouldn't be able to enforce appraisal in that context.
Okay, so going back to my original experience, when the insurance company agrees to go all the way through the process, and in the case I'm thinking of, we went all the way through the umpire process. The umpire made the ruling, signed the ruling. 2 of the 3 parties agreed, as you outlined in your process overview, and then the insurance company said, well, we disagree, we're still not going to pay. Can they do that? Is that legal?
The short answer is yes, and it's certainly not illegal. And what a lot of times we have to remember in this context, insurance is a business, and so they're making business decisions, and it doesn't really have to do with legal or illegal, but it has a lot to do with what's in their best interest and what's in the policyholder's best interest, right? And so the simple answer is yes, they can do that. There is a lot of confusion, especially today in Texas, about what factual disputes does an appraisal award actually define? What does it set? What can you no longer dispute after that appraisal award comes out? And some of it stems from, some, I would say, less than clear judicial precedent that we have in Texas, because there is this discussion of causation and whether an appraisal panel can get into causation. And there's factual causation and legal causation, and exactly where does that line get crossed? So the way we typically explain it to clients is, when you have an appraisal award, the amount of the loss is set. They're really absent some very specific circumstances like fraud or mistake or accident in the actual appraisal process. The amount of the loss is set. The insurance company can still dispute the entirety of the claim or the loss through causation. They can say, that's great, that's how much it costs to replace your roof, but we don't think we owe you for any of that roof because we don't think it's covered under the policy. So you can still have a coverage dispute after an appraisal award, because in Texas, the appraisal award is not allowed to determine coverage under the insurance policy.
Okay. So when that happens, in your opinion, what's the right next step for a policyholder to do?
If a claim is denied following an appraisal, typically you're going to want to come talk to somebody like me who can review your policy for coverage and give you advice and opinion as to whether or not the loss is covered under the policy, to give you what your steps could possibly be. Because sometimes the best thing I can offer somebody is closure and say, listen, I'm sorry, but it's not covered. And so that way you're not going about wasting your time moving forward, attempting to fight something that just clearly is not covered under the policy.
Yeah, and I've Jonathan, I've also seen really tough arguments regarding method of repair. They start coming up with these other terms, if you will, and to try to get around the issue of coverage and causation, to weave that into the dispute, even though when there was an agreement to go to the appraisal, no coverage issue was raised. Right now, suddenly we get into the appraisal process, and they're seemingly adjusting the claim still. It's almost as if they're just continuing to do their investigation of loss. And now they bring out all their causation experts under the premise that they're investigating the method of repair, as opposed to calling it a causation issue or a coverage issue. So I think for some of our listeners today, just to consider and to remember and to think about that. This is as the policy and as Jonathan very eloquently stated, about setting the amount of the loss. And I do know that there are some precedent out there regarding method of repair. But what does that actually mean? It's not within the context of the policy, but I do know that it sometimes enters the conversation when dealing with some of these umpires. Whereas opposed to someone wants to clean something versus replacing something, and they say that that's a method of repair issue. Even though they did not raise an issue when they were given an estimate of damages that included the replacement prior to going to appraisal. Now, I know I'm getting in the weeds here, getting a little more complex and a little niche, but I do know this is an issue for like hail claims. A lot of times they come out and they say, oh, it's only a few shingles, even though the only thing that's been ever represented is the replacement of the whole roof. Now they're like, well, it's a method of repair issue, and that goes to the amount of the loss. And so there's a disagreement as to that, and we need to deal with that issue first before we set the amount. Confusing. And also, I think it kind of bogs the process down. And quite frankly, why the appraisal process a lot of times is broken nowadays. Because as people start to enter, add these things, these issues or aspects into it, into the process. Jonathan, I wanted to ask you about, when your firm is getting these claims, and you're dealing with the appraisal process, where do you see the role of a public adjuster or representation early on, and what can a public adjuster do to advantage a client that may go into the appraisal process?
What I typically, when I speak to public adjusters, and I do think that they have a role in the system, especially when you get into the more complex commercial losses, because good public adjusters are experts at documenting claims and making sure that files are tight, put together, and consistently corresponding with insurance companies. And so there are very few insureds that I've ever met that are capable of going out, especially on a commercial loss, and estimating the entirety of the damage and putting that in a package that an insurance company can digest. Because let's face it, these days, the adjuster that you're likely going to get from an insurance company, you're not going to be their only loss, right? And so the easier you can make it on that adjuster, the more attention you can get, or the more quickly your loss can be looked at one way or the other, right? And so I think that one fantastic role for public adjusters is assisting property owners, if we're talking about property damage cases, early on in an evaluation to assist in presenting a package to the insurance company that's easily digestible. And then, public adjusters are also good at handling coverage issues, right? If they have some sort of a coverage issue, to assist a policyholder in navigating through the complexity of an insurance claim. Because one thing, and even in the last 12 years that I've been doing this, one thing that has not happened is that insurance claims process has not gotten easier. It hasn't gotten more succinct, and it hasn't become more easily navigable for insureds. And so public adjusters have a fantastic role in assisting insureds navigating through that process. Because as we've already talked about this morning multiple times, random person off the street, regular business owner, doesn't understand the complexities of these policies, and how, when you're talking about, exclusions and exceptions to exclusions and ensuing loss provisions, which one do you read first and which one gets trumped? People don't understand that. I mean, it's a very difficult and complex system.
Absolutely. And I think the appraisal process is incredible when it works. That you talked about closure. I love what you say. It's like sometimes the best thing you do is just give closure, right? It has the ability to do that, to bring the closure, either, in favor or against. Either way, it's closure. And it's an awesome tool and a way to get these things resolved. And I know our Texas office has been engaging in the appraisal process, and it's been working It's just these outliers, and that's why I bring up the issue of the method of repair, because it's, just there's things I know that there's things you can do leading up to the appraisal process, and we don't represent everyone. So, if they're listening in and hearing this, these are some of the things to look for as you're headed towards a dispute, and you could forecast one. What can you do to advantage yourself in that process? And thinking that way, to avoid these issues of method of repair, why not ask the question a little bit earlier before you get in the process, things like that, to obtain that closure that you talked about. I think it's been fantastic. Rob, I know you've been struggling with some of those appraisals out there and dealing with some of these panels, but the most of them have been fantastic. I mean, I think it's just a great process, and Texas does it better than Florida for sure, all day long.
Yeah, what's interesting is like everything, it's a smaller industry than you realize. And if you can get the right people involved, it's not so much on the award outcome, which is also nice, but it's just the timing of the process. If you can get people that want to resolve it quickly, that's when you have a happy policyholder. It's when the insurance company appoints somebody from maybe out of state and they say, well, I can't get there till next month. And then there's another 2 months while they make their determination. That's when it really becomes a challenge for policyholders. And I think that's an intentional act on behalf of the insurance companies. So Jonathan, thank you for being with us today and providing a lot of insight into the appraisal process. As we close out, just tell us where can people find out more about Gravely? How do people get in contact with you?
Yeah, I appreciate your time today. It has been a great time speaking with both of you. Our law firm website is gravelylaw.com. You can come find a wealth of information on that website. We've got our amicus efforts that we represent on behalf of policyholders in general. And that's one thing I didn't talk about earlier, but we represent individual policyholders, but we also represent in our amicus efforts groups of policyholders on the behalf of policyholders generally. So you can read about our amicus efforts on our website. You can get in contact with us and you can see a little bit more about our firm. So thank you, guys.
Hey, Dan, thanks for letting us give an update from Texas, and have a safe trip back to Florida, and keep that suitcase packed because you're going to be here for our 1-year anniversary and holiday party next week.
Yeah, man, I can't wait. Jonathan, thank you so much for coming on today, taking time. I know time is valuable, and particularly nowadays, it's awesome to get you guys in the same room though, and talk about an important issue. I think it's an issue that needs more attention to help people get that closure. Leaving it on that note. So again, thanks, Jonathan, and yes, I cannot wait to join you, Rob, in Texas to celebrate 1 year, to celebrate the holidays, to close out the year on a high note. I love this time of year. That's why I'm on the road live from New York. I'd like to say it that way, and enjoying some colder weather. It's a little hot in Miami, so I'm escaping it for a few days here. But thanks again, guys. Thanks so much for joining us. All right, guys. Well, that was an awesome episode talking about an issue that definitely needs a lot more attention. We need to be talking about things like that. How do you get these things done? And as you heard from Jonathan, he talked about closure. That's what it's about. But we want to make sure that you're getting everything that you're entitled to. We want to make sure that that product is working for you. And people like Jonathan and his firm are doing amazing things, making sure that they're on the front lines, helping policyholders do what we do, right? We help policyholders take advantage of the policy, the product that they purchased in the right way, making sure that they're making proper claims, making sure that they're looking at every possibility for coverage and doing it to make sure that they can actually restore their property, to that their business can continue to operate, that their association can financially survive and continue to move on. There's no reason to pay for insurance and not use it when you need it most. And that's what this is all about, is making sure that you have the information you can use. We do this every single week right here on our Cover Report Live, and I'm live from New York, meeting with clients, ending out the year. I'm excited for what 2023 has in store. The next few broadcasts are going to continue on this high note. We're going to be high energy. We're going to be excited for what's to come. We're going to make sure that you continue to get that information. If you haven't already, hit the subscribe button, like us, follow us on all those social media. We want to make sure that you have that information you can use, and there's no better place to get it than right here on their Cover Report Live. So we'll see you next time, same place, right here on their Cover Report Live.